Within the last 48 hours, Canada made a defense policy decision that shocked Washington. This was first reported by Reuters and confirmed by Global Affairs Canada on June 14, 2025. If you're a foreign national working in defense, tech, or government contracting on U.S. work visas, this directly impacts you, your security clearance eligibility, your visa renewals, your pathway to permanent residency, all of it. This isn't speculation. This is a documented strategic realignment. The Department of Defense, DHS, and USCIS are already reviewing internal policies, and most visa holders in sensitive sectors, they have no idea this is happening. If you're on an H-1B, L-1, O-1, or employment-based green card track in a field tied to national security or international partnerships, stay with me. The next 14 minutes could be the most important update you watch this month. My name is Eugene Lansing. I'm a senior immigration analyst and consultant. On this channel, I break down complex immigration developments into clear, fact-based analysis you can actually understand and act on. One principle drives everything here: policy-based clarity, not rumor-based panic. I don't traffic in fear. I give you the legal framework, the regulatory context, the strategic implications, so you can make informed decisions about your immigration future. Quick disclaimer before we continue. I am not your attorney. This content is for educational and informational purposes only. Always consult a licensed immigration attorney about your specific case. Everything I'm sharing today comes from publicly available policy documents, government statements, and regulatory frameworks. Now let's break down exactly what happened, why it matters, and what you need to do next. Here's what happened. The Canadian government announced a formal defense and security cooperation agreement with the European Union. This agreement includes intelligence sharing protocols, joint defense procurement standards, and coordinated export control enforcement. Now, on the surface, this sounds like standard international diplomacy. Two allies signing a cooperation agreement. Happens all the time. But here's why this one is different. Here's why this one matters for U.S. immigration. This agreement includes provisions that allow Canada to align its technology export controls and foreign national employment restrictions with EU standards. Not U.S. standards. EU standards. Let that sink in for a moment. For decades, the Five Eyes Alliance, the U.S., Canada, UK, Australia, and New Zealand, has operated under shared intelligence frameworks, shared security protocols, shared vetting standards for foreign nationals working on sensitive projects. Canada was our closest ally in this structure. Geographic proximity, economic integration, defense cooperation. The U.S.-Canada defense relationship was considered unshakable. Now, Canada is pivoting toward Brussels. They're aligning with European frameworks instead of American ones. And that changes everything for how the U.S. government views Canadian partnerships and the foreign nationals who work within them. This decision was made at the ministerial level in Canada, specifically through their Department of National Defense and Global Affairs Canada. It was not a sudden move. Intelligence sources suggest this has been in development since early 2024. But the formal announcement caught U.S. defense and intelligence officials completely off guard. The Pentagon was not consulted. The State Department received minimal advance notice. This was a deliberate Canadian decision to diversify their security partnerships away from exclusive U.S. alignment. The Pentagon's response was immediate. Within 72 hours of the announcement, the Department of Defense initiated what's called an Allied Access Review. What does that mean in plain English? It's a security audit, a comprehensive review of how foreign nationals from allied countries, including Canada, are vetted for work on U.S. defense contracts, particularly contracts requiring security clearances or access to controlled technologies. And this is where USCIS enters the picture. This is where immigration law intersects with national security policy. Under the Immigration and Nationality Act, specifically Section 212A, 3A, the Department of Homeland Security has broad authority to determine whether foreign nationals pose security concerns that could affect visa eligibility. When the Department of Defense requests enhanced vetting protocols for nationals of specific countries, Even allied countries, USCIS and the State Department typically comply. They do this through administrative guidance, internal policy memos, field office directives. This means changes can happen fast, with little public notice, no Federal Register announcement, no comment period. You just start seeing longer processing times, more requests for evidence, security clearance delays that stretch from weeks into months. Under the Administrative Procedure Act, agencies like USCIS can implement interim guidance without formal rulemaking if it's classified as an interpretive rule or policy statement. They don't need congressional approval. They don't need public input. They just do it. And that's exactly what's happening right now. Let me be very clear about who this impacts directly. First category, H-1B visa holders employed by defense contractors, aerospace companies, cybersecurity firms, or tech companies working on government contracts. If your employer has contracts with the Department of Defense, you're affected. If your employer works with the Department of Energy on nuclear or advanced technology projects, you're affected. If your employer provides services to intelligence agencies, even indirectly, you're affected. Your visa renewal could face additional administrative processing. Your adjustment of status application could be delayed by months. Your security clearance application, if you have one, could be flagged for enhanced review. Second category, L1 intracompany transferees working for multinational corporations with defense sector exposure. If your company does business with NATO countries, pay attention. If your company is subject to international traffic in arms regulations, known as ITAR, pay attention. If your company manufactures, exports, or services defense articles or defense services, your transfer petition could be significantly delayed. The L1 visa is already under heavy scrutiny. This geopolitical shift adds another layer of complexity. Third category, employment-based green card applicants in EB2 or EB3 categories who work in dual-use technology fields. What does dual use mean? It means technology with both civilian and military applications. Artificial intelligence, quantum computing, advanced semiconductors, aerospace engineering, satellite technology, autonomous systems, biotechnology with defense applications, cybersecurity tools, encryption technology. If your work touches any of these fields, even tangentially, you're now in a higher scrutiny category. But here's what many people are completely missing about this situation. Even if you don't work directly in defense, this policy shift creates a massive ripple effect across the entire immigration system. Here's how it works. When USCIS implements enhanced vetting protocols for certain employment sectors, it pulls adjudicators and resources away from general case processing. The agency has a finite number of officers, a finite budget, finite processing capacity. When national security cases get prioritized, and they always do, everything else slows down. That means longer processing times for I-140 immigrant petitions, longer waits for I-485 adjustment of status applications, delays on routine I-765 employment authorization renewals. Even I-131 advance parole documents could take longer. The entire system gets backed up, and visa holders who have nothing to do with defense or national security end up paying the price through extended wait times. Now here's one detail that most people are completely overlooking. If you're a Canadian national working in the U.S. on a visa, any visa, your case may now be subject to additional scrutiny. Not because of anything you did, not because of your employer, not because of your field. Simply because of this geopolitical realignment between Ottawa and Brussels. The same applies if you're a dual citizen with Canadian citizenship, even if your primary nationality is something else. Even if you've never lived in Canada. If Canada appears anywhere in your immigration file, it could trigger enhanced review. This is how national security policy works. It's broad. It's categorical. It doesn't account for individual circumstances. The Canadian-EU agreement is set to take effect in phases over the next 18 months. Implementation will be gradual on the Canadian side. But the U.S. response, the enhanced vetting protocols, could begin as early as the next fiscal quarter, possibly sooner. Typically, when the Department of Defense requests immigration policy adjustments, implementation happens through internal USCIS field guidance. You won't see a press release. You won't see a Federal Register notice. You won't get an email notification. You'll just start seeing longer processing times. More requests for evidence with detailed questions about your employer's contracts. Security clearance delays that your company's FSO can't explain. Administrative processing holds that stretch for 6 months, 9 months, sometimes longer. This could affect you even if you're not in a defense-related job category. That's the reality of how interconnected the immigration system is. Let me give you a realistic scenario so you understand how this plays out. Imagine you're a software engineer from India. You're on an H-1B visa. You've been working for a tech company in California for 4 years. Good salary, good reviews, stable employment. Your employer sponsors your green card. You file your I-140 petition, it gets approved. Everything looks good. You're waiting for your priority date to become current so you can file your I-485 adjustment of status. Your company doesn't make weapons. You've never had a security clearance. You work on commercial software products, consumer applications, nothing military. But here's the thing. Your company also provides cloud infrastructure services to a federal agency. Maybe it's the Department of Veterans Affairs. Maybe it's the General Services Administration. Maybe it's a subcontract through a larger federal contractor. Under ITAR and export control regulations, that relationship, even if it's a small part of your company's business, could classify certain work as sensitive. You didn't know this. Your manager didn't tell you. It wasn't in your job description. Suddenly, 6 months after filing your I-485, USCIS issues a request for evidence. They want detailed documentation about your employer's government contracts. They want to know your specific access levels to controlled technologies. They want information about whether any of your work could be subject to export licensing requirements. Your immigration attorney is confused. This was supposed to be a straightforward case. You're not in a sensitive role. You don't have access to classified information, but your attorney makes some calls, consults with colleagues, and explains what's happening. This is part of a broader security review. It's triggered by changes in allied intelligence sharing agreements. USCIS is casting a wider net, asking more questions, taking longer to adjudicate. Your case, which should have been approved in 4 to 6 months, is now stuck in administrative processing. 6 months pass, 9 months pass. Your attorney files inquiries. USCIS responds with form letters saying the case is still pending. Meanwhile, your H-1B is approaching its 6-year maximum. Your company's HR department is getting nervous. Other job opportunities pass you by because you can't switch employers while your green card is in limbo. That's not a hypothetical scenario. That's the reality thousands of employment-based applicants could face in the coming year. So, what do? Here's your step-by-step action plan. Step 1. Audit your employment situation immediately. If you work in technology, aerospace, defense, cybersecurity, or any field that could be subject to export controls, you need to understand your exposure. Document everything. Know what government contracts your employer holds. Know whether your work falls under ITAR or the Export Administration regulations. Know what classification levels your company works with. If you're not sure, ask your manager. Ask your company's legal department. Ask your FSO if your company has one. Get clarity now before USCIS asks you these questions. Step 2. Organize your immigration documentation. Make sure every document related to your immigration status is current, accurate, and accessible. Your passport. Is it valid for at least 6 months? Your visa stamps. Do you have copies? Your I-94 arrival, departure records. Have you verified them online? Your employment verification letters. Are they recent? Your tax returns. Are they filed and accessible? If USCIS issues an RFE, you need to respond within the deadline. That's typically 87 days, but some RFEs have shorter windows. Don't wait until you receive one to start gathering documents. Be ready now. Step 3. Monitor USCIS processing times and policy updates religiously. Set up case status alerts on the USCIS website. Check your case status weekly, not monthly, weekly. Monitor the USCIS processing times page for your service center. Look for unusual patterns. If you see processing times suddenly increasing for your case type, that's an early warning sign. If you see a spike in RFEs for cases similar to yours, that's a signal. Pay attention. If you notice anything unusual, contact your immigration attorney immediately. Don't wait. Don't assume it will resolve itself. Step 4. Avoid status violations at all costs. This is not the time for mistakes. This is not the time for shortcuts. Do not overstay your authorized period of stay. Not by 1 day, not by 1 week. Do not work without proper authorization. Do not assume that a pending application automatically protects you from enforcement. In a heightened security environment, technical violations that might have been overlooked in the past can have severe consequences. ICE is active. Enforcement priorities can shift. One mistake can derail years of careful immigration planning. Step 5. Be extremely cautious of immigration scams and misinformation. When major policy changes happen, scammers come out of the woodwork. You're going to see panic-driven content all over social media. YouTube videos with alarming titles. WhatsApp forwards with false information. Reddit posts from anonymous accounts claiming insider knowledge. Don't fall for it. Verify everything through official government sources. USCIS.gov, state.gov, DHS.gov, Federal Register notices, or consult with licensed immigration attorneys who can actually interpret policy documents. Do not make life-changing decisions based on social media posts or unverified claims. The stakes are too high. And most importantly, consult a qualified immigration attorney who understands both employment-based immigration and national security law. This is specialized knowledge. Not every immigration lawyer handles these issues. You need someone who understands ITAR, someone who understands export controls, someone who has experience with cases involving enhanced security vetting. This is not the time for DIY petition filing. This is not the time to rely solely on your company's HR department. Get proper legal counsel. So what happens next on the policy side? First, we need to watch for any formal policy guidance from DHS or USCIS. If the Department of Defense formally requests regulatory changes, we could see updates to the Foreign Affairs Manual. That's the document that governs how consular officers adjudicate visa applications abroad. We could also see internal USCIS policy memoranda, updates to the adjudicator's field manual, new guidance to field offices about how to handle cases involving allied nationals in sensitive sectors. I'm monitoring all of these sources. When updates come, you'll hear about them on this channel. Second, expect potential litigation. If these enhanced vetting protocols disproportionately delay applications from nationals of specific countries, immigration advocacy groups will challenge them. The legal arguments would likely be based on the Administrative Procedure Act, arguing that the government failed to follow proper rulemaking procedures, or equal protection grounds if the policies discriminate based on national origin. Litigation takes time, years sometimes, but it's an important check on executive overreach. Third, understand that this is part of a broader trend. The U.S. government is increasingly scrutinizing foreign nationals in STEM fields and defense-adjacent sectors. We saw this with executive orders targeting Chinese nationals in sensitive research positions. Presidential Proclamation 143 restricted certain Chinese graduate students and researchers. We've seen enhanced vetting for nationals from other countries too: Russia, Iran, countries considered strategic competitors or adversaries. Now we're seeing these frameworks applied to allied countries that are realigning their security partnerships. Canada today. Others possibly tomorrow. This is the new normal for employment-based immigration in sensitive sectors. Could these policies change? Yes. Geopolitics is fluid. If U.S.-Canada relations stabilize, these protocols could be scaled back. If the EU agreement is modified or doesn't deliver what Canada expected, Ottawa might pivot back toward Washington. If a new administration takes a different approach to allied relationships, policy could shift. But all of that takes years. In the meantime, visa holders are navigating uncertainty. You have to plan for the world as it is, not as you hope it will be. Let's be very clear about what's at stake here. Your immigration status affects everything in your life. It affects your ability to work and provide for your family. It affects your career mobility, whether you can change jobs, get promotions, pursue opportunities. It affects your financial security, your ability to buy a home, plan for retirement, build wealth in this country. It affects your personal life, whether your spouse can work, whether your children can study without disruption, whether you can travel internationally without fear of not being able to return. It affects your long-term future, your pathway to permanent residency, your eventual eligibility for citizenship, your ability to put down roots and build a life here. A 6-month delay in your green card application isn't just bureaucratic inconvenience. It could mean losing a job offer because a new employer can't wait for your transfer. It could mean being separated from your spouse or children if their status is tied to yours. It could mean watching your priority date retrogress while you're stuck in administrative processing, adding years to your wait. Immigration law is unforgiving. It does not care about your intentions. It does not care about your circumstances. It does not care that you've done everything right, paid your taxes, contributed to your community. It cares about compliance, documentation, procedure, deadlines. That's why staying informed is not optional. It's essential. It's the difference between navigating this system successfully and being blindsided by changes you didn't see coming. If you want accurate, fast, and reliable immigration updates, subscribe to this channel right now and turn on notifications. Immigration policy is changing rapidly. What's true today might shift tomorrow. You need a reliable source that cuts through the noise and gives you actionable information. Drop a comment below with your visa category. Tell me if you're H-1B, L-1, O-1, green card pending, working in tech, working in defense. Whatever your situation is, let me know who's watching so I can prioritize content that helps you specifically. Share this video with anyone you know who works in tech, defense, or government contracting. They need this information too. Most people in these sectors have no idea this policy shift is happening. You could be the person who helps them protect their immigration future. And hit that like button. It helps the algorithm. It supports fact-based immigration coverage. It tells me this content is valuable to you. I'm Eugene Lansing. Stay informed, stay compliant, and I'll see you in the next update.